I don't recall exactly. My guess is 3-2, but sorry.
3-2. We're hearing. We see fingers in the back of the room. 3-2. 3-2.
I will remind you
We
that
think
is enough to double people's property taxes. I mean, that's the position of the City of Rockville, that we strongly support the current provisions.
Okay. Thank you.
Further questions for Mr. Moore? Seeing none, thank you very much. Oh. Yeah, I was taking them separately because one was opposition, one was information. Thank you. You can leave the table or stay. Now let's go to the commission. Not that I want you to read it, but you may want to pull his testimony from the file.
Thank you, Mr. Vice Chair, Madam Chair, members of the committee. I just want to add a few observations. I think we pretty well spelled out in our written testimony kind of the experience of the State Ethics Commission since 2010 when we began implementing the changes to the law that were brought about by Senate Bill 315. And my point is only to make clear that we have some reservations and some concerns if the decision is made to sort of roll back some of what was done in 2010. 2010, the big change to the state ethics law was that at that point, Senate Bill 315 said going forward, elected local officials would be required to follow the conflict of interest provisions in the law and the financial disclosure provisions in the law at an equivalent basis to those that apply to you all. In other words, before 2010, there were still requirements for the local governments to have laws, but they needed only to be similar. Going forward, they had to be equivalent. And while no one seems to be complaining, or there's very few complaints about strengthening the conflict of interest provisions, the focus has been for the last 5 years, and as you heard today, is on the equivalent financial disclosure provisions. And so those are provisions that you have to disclose, or they have to disclose now under the law as enacted in 2010, exactly what you have to disclose, what I have to disclose as a state employee, and what some 14,000 other state employees have to disclose. And many of those 14,000 state employees are earning a grade of earning about $42,000 a year. So it's important to keep that in mind. It's not just for the high-level personnel in the state, and so it's simply asking for a disclosure at a similar level to what, or equivalent level to what state officials and state employees provide. As far as the burden on small municipalities, I think it's really important to understand there is no provision for exemptions for counties. Counties cannot be exempted from the law. They're obliged to have the law as it's carried on the books. But there's a provision that allows the State Ethics Commission, based on the size of the municipality, to exempt smaller municipalities from having a law. And there are some 82 municipalities that, based on the review of the State Ethics Commission, have been granted a full exemption, meaning they don't have to have an ethics law at all. So therefore, the municipalities that are affected are those that are larger and arguably carry out greater functions. They work with a larger budget, have more employees, and so that's who's really affected. It's the larger municipalities, because, as I said, there's been a consistent theme of the Commission granting exceptions to or exemptions to these small entities. As I stated in my written testimony, I think there's some misunderstandings, and I just want to quickly clear up a couple things, because it's not as bad as it seems. Spousal information is not required to be disclosed unless that information is, for instance, in a jointly held piece of property. If I share a house with my wife, as I do, I have to report it. But if she holds a home in her own name as a non-state employee, that doesn't get reported. We don't have to disclose any stocks or bonds or other types of financial interests that she has, because she's not the state employee. It's the jointly held information. The one thing that I do have to disclose about her, and that they have to do at the local level as well now, is they have to disclose where your spouse works, in case, and not how much your spouse makes, but just where your spouse works, or if your spouse owns a business, the name of that business. And that's pretty much the extent of it. There's a very limited situation where you might have to disclose something about a dependent child and where that child works, but again, a very limited basis. There's no requirement for any of us to disclose mutual funds. That's a change that was made to the law that affects you and local governments, therefore, in 2013. And the Commission just asked me to convey a concern that if we're going to attach confidentiality requirements to a disclosure, makes you ask the question, if we call it financial disclosure, how is it disclosure? If it's being tucked away in a file only to come out under very limited circumstances. So I'm reminded, Jack Lapidus, one of your former colleagues for many, many years, who served on our commission for 12 years, made the observation that when this law was enacted in 1979 and applied to the members of the General Assembly, there was an initial resistance to it as well. Here we are 36 years later. I think it works pretty well. And now, again, it's a policy decision as to whether it ought to be amended at the local level, and the Commission obviously defers to you all. I think you've heard that the Commission is not enthralled by this law, but again, in terms of opposing it, Commission, we don't oppose it. We do want you to take into account some of the concerns, though, that we have. And thank you for giving me an opportunity to speak to you today.
Questions for Mr. Lord? Senator Rosapep, followed by Senator Montgomery.
Same question I asked the earlier panel. Are you aware of how many convictions for bribery there have been of municipal officials in Maryland over the last decade or so?
I have no idea, Senator.
Thank you.
Senator Montgomery.
And mine is, what is the size of the municipality that is excused because it's so small?
Well, there's not a number, because there's 4 factors that the Commission is required to take into account. Population being obviously important, size of the budget, which a large budget in a smaller populated municipality may throw it into the category of having to disclose, number of municipal employees, and the type of services rendered. I would say somewhere just shy of 2,000 people in the municipality has been sort of a rough estimate, if you're interested in population, about where the cutoff has been, something lower than that, but not significantly. And again, a lower populated entity could still file.
Thank you.
Just following up on that, a number of jurisdictions have been rejected for an exemption,
Yes.
correct? Can you give us how large a number, or what kind of budgets or sizes, cities or towns were they? I mean, we could probably name them if we had to. Is it a large number, a small number?
Well, we're getting into the $2 to $3 million range in budget size. And again, I'm generalizing, obviously,
We
Senator.
understand.
But of course, you also look at what kind of functions they're carrying out, how many people they employ. So it's not just tied to budget either. But again, $2 to $3 million is probably a good number where you'd expect them to have to enact a law.
Thank you. Further questions? Seeing none, thank both of you for your time and patience. That concludes the hearing on this legislation. Madam Chairman.
Thank you. We're going to move now to Senate Bill 340, voting rights, ex-felons voting rights. And we have Nicole Porter, Thomas Lopez, Adrian Muldrow, Perry Hopkins, Craig Carpenter, and James Grayson. And let me just give you a little history on this bill. Sarah Penske was here at the time. We've been working on voting rights for a long time, even during the time that Senator Blunt was here. In 2007, we made a change again. And in looking at the bill and the Voting Rights Act, in terms as it relates to felons, it appeared to me that in many instances, whatever the crime is, it has no association at all with voting. And when you look at the crime or the conviction, I mean, it's not voter tampering. It's not any of the things related to voting. So, you know, in my opinion, as I continue to look at it, it just seems to be another form of voter suppression. And from 2010 on, the National Conference of State Legislators consistently look at the Voting Rights Act and the individual's right to vote, and they have made it a priority to consistently reduce and allow individuals who have convictions to vote. So what we're doing with this particular bill is, I am saying, just based on the way that the bill is crafted, that once you finish your sentence, so we're going to eliminate the probation and parole and all of these other criteria that prohibit individuals from voting. The only thing that I did notice that it does have a fiscal note, and I have a question of elections once the panel testifies. So we want to make it as small. Don't go anywhere, Ms. Make it as, we're going to reduce the fiscal note as small as possible, but I'm going to allow you to testify. But that's basically what the bill does. It also says that upon release, that the Department of Corrections must submit a list and have a procedure for allowing individuals discharged to allow them that their voting rights have been restored, and tell them and educate them on where and how to vote. Questions, committee? All right, we're going to start with our first panelist, is Nicole Porter from the Sentencing Project.
Great. Thank you so much. Thank you, Senator Conway, and to the committee for hearing this important legislation this afternoon. The Sentencing Project is in full support of Senate Bill 340. We're a national organization focused on tracking trends in incarceration and look at collateral consequences, of which the denial of voting rights to people with prior felony convictions is considered in that category. Nationally, millions of people are disenfranchised from the vote because they have a felony conviction. Many people think that those are folks who are incarcerated. Actually, the majority of people who are disenfranchised are living in the community, still under community supervision on probation or parole. And Senate Bill 340 importantly corrects that problem. In Maryland, this measure would expand the voting right to 40,000 Marylanders, expanding democracy and strengthening the electorate for the democratic process. Many people are concerned with public safety when issues related to sentencing and issues relating to collateral consequences for persons with felony convictions are introduced and debated in state legislatures. And it's important to recognize that there is evidence showing that enfranchising people with felony convictions emboldens pro-social networks and pro-social activity, such as voting, also fully participating in one's community, and that is connected and correlated to reducing recidivism and reducing future contact with the criminal justice system. It's also important to recognize that law enforcement has come out in support of this measure nationally. You all have testimony from the American Association of Probation and Parole, who are strong advocates in support of voting rights for people with prior convictions, and they recognize the pro-social benefit of engaging people with prior justice contact, justice involvement in future democratic processes, so that their connections to the community are strengthened and that reduces future recidivism. I just want to wrap up my comments by saying that Maryland is one of 2 states looking at expanding voting rights to people on community supervision this year. Also, Minnesota is debating legislation this year that a similar measure, and that measure has garnered significant bipartisan support in the state of Minnesota. And so this measure isn't about politics. It isn't about one party or the other. There is bipartisan consensus and also law enforcement support to expand voting rights to people with prior convictions. I'll say if lawmakers do pass this bill, this would move Maryland into a category of 13 states that allow folks to vote who are living in the community under supervision, and other states include Pennsylvania, Ohio, and Indiana. So it's a range of states with different political orientations that have similar policies that you all are looking at in Senate Bill 340. So again, I want to reinforce that the Sentencing Project is in full support of this measure.
Thank you. Next.
Thank you, Senator Conway. Thank you, members of the committee. My name is Tomas Lopez, and I'm with the Brennan Center for Justice at NYU School of Law. We're a law and policy institute that works on issues of democracy and justice, including felony disenfranchisement. I'm grateful for the opportunity to be here. We've submitted written testimony, and I want to use my time here to point out 2 reasons why SB 340 is good public policy, echoing the points that Nicole made. First, that it will facilitate the reentry process for people returning from prison and rejoining their communities. And second, that it will simplify Maryland's law, reducing, we argue, the burden on election officials. As to the first point, we support this as a measure that will integrate newly released prisoners into their communities. Nicole mentioned the testimony of the American Probation and Parole Association, which you all have received. Law enforcement professionals believe that civic engagement can help a person invest in their community, and that there's no more fundamental form of that investment than voting. Moreover, it's a way in which people who are brought back into communities can start seeing themselves as part of their community. And again, as Nicole mentioned, there is a body of research that supports the idea that people who have the right to vote recidivate less frequently than those who do not. The second point I want to stress is that Maryland's law currently requires the exchange of information between election officials and the court system on who has a felony conviction, where do things currently stand, and the key flaw in this, one key flaw in this system is that on top of everything else that election officials have to do, this information has to be up to date in order for the law to be fully and properly applied. That means that the system we have now is vulnerable to misapplications of the law and outdated information. By creating the most straightforward rule possible, that if you're out of prison, that you're permitted to register to vote, that's going to make Maryland's law easier to implement. The rest of the panelists, you're going to hear firsthand from some of the individuals who are directly affected by this law, and they'll further illustrate the flaws. But I want to urge you to also consider the broader benefits of reentry and to simplifying the state's felony disenfranchisement law. We believe these benefits are worthwhile and the bill is sensible and smart.
Thank you. Next, give us your name.
Good afternoon, Senator Conway and committee. My name is Greg Carpenter, and I just want to thank you for the opportunity to be here today to share some insight and inform the conversation about why Senate Bill 340 is sensible and right legislation. I was formerly incarcerated. I spent 20 years in prison. Fortunately, I've been home a little over 20 years. 19 of those years I've been employed in the state of Maryland working as a productive citizen, and I've been unable to vote. And I'm a homeowner, and I pay taxes, but I'm disenfranchised. And I think that with this process that we are looking at now, if we can see that it is sensible and to vote in favor of this bill, then I think I represent a lot of individuals who anxiously want to participate fully in this democratic process. And I work at an organization where I work with people directly who are impacted, who come home every day from prison and wanting to be re-engaged and re-enfranchised into our process. And there are certain things that prohibits them. And this just happens to be one of those things. And so just one other point is that right now in Baltimore City, approximately out of the 14,000 or so individuals that come back to communities, about 9,000 of them come back to Baltimore City. And so we know that Baltimore City has a high crime rate. And as the two people that spoke before me talk about how this could impact in a positive way recidivism. And so again, as a person who is on the front line doing the work every day, we see that this can have an impact in a positive way. And so just in closing, I would simply say that, voting is the most important exercise a citizen would do as a responsible citizen of a democratic nation. Therefore, I urge you to vote favorably for Senate Bill 340.
Thank you. Next.
Thank you for having me here today. My name is Perry Hopkins. I'm an ex-offender. I have served over 15 years in the
Perry, pull the mic closer to you. Okay.
I'm sorry. Is that better?
All right.
Okay. Hi, my name is Perry Hopkins. I am an ex-offender and ex-felon. I have served over 15 years in the Maryland State Prison System. I have successfully completed my parole after having served last a 4-year sentence. Part of the reentry process is finding ways to give back to a community that I, for so many years, have eroded. Currently, I'm an intern organizer with Communities United, and I work to mobilize ex-offenders to register and to vote. Also part of the reentry process is our return to society and taking a place fully in the citizenry of our communities. The current law disenfranchises not only myself, but many people on parole and probation and those coming home. We're expected to act and conduct ourselves as productive citizens, but we're not allowed to participate in the process of the rights of normal citizens. The right to vote is an important part of the reentry process. And participation in the democratic process helps to restore us to feeling a real part of society. Right now, the current law alienates us, and that alienation is dangerous. Those feelings of alienation can lead to, for many, recidivism. I can directly reflect in my own personal life the feelings of that alienation. In 2008, this great nation elected the first Afro-American president in this great nation's history. At the time, I was on parole and probation, and I was unable to vote. I remember watching everybody in the streets cheer and say, "We have a new president." Did you vote? And I couldn't say yes. It was this law that made me a witness of history rather than a participant in history. That psychological effect for many is a little more than they're able to overcome. Fortunately for me, I haven't succumbed to that. But I speak not only for me, but I speak for many, many, many people just like me. And it's for those reasons that I ask you all to support SB 340. Thank you.
Thank you, Perry. Next.
Morning, Mr. Chairman. I am a concerned citizen as well as an ex-offender. My name is James W. Grayson. I am the son of one of the Martinsville Seven. Just what is the Martinsville Seven? It was a case involving 7 men who were convicted in 1949 for a rape they did not commit. They were all executed by way of the electric chair in 1949 by the state of Virginia. I am also an ex-offender who witnessed a crime take place in 1964, went to the authorities to report what I had witnessed, was charged and sentenced to life plus 15 years. Although I had nothing to do with the murder, I am deeply sorry that a man with a family lost his life as well as the family's loss. After almost 50 years, I was finally released because of a bogus jury instruction which should have been corrected in 1851. By the grace of God, the Unger decision allowed all affected by this jury instruction to be released. I was released and sent to a transitional housing facility. I was awarded supplemental security benefits until I decided to marry. After my marriage, my benefits was denied. Once married, I moved in with my wife. When the lease was renewed, my wife included my name on the lease. A background check revealed my past, and I was threatened and ordered to vacate the premises. Since then, I have been ordained as an elder at my church. For all who are pending release, I ask that this bill, SB 340, be passed so that they will have a fair chance at securing a living, including housing, employment, and most of all, that they may have their voting rights, that they would feel like people care because, rather, would care and welcome them back into society. Thank you.
Thank you. Thank you. Question, Senator Somnier.
Thank you, Madam Chair. It may be a question to you, but first I wanted to thank you for your testimony. It was very heartfelt, and I appreciate that. Let you kind of know where I came from. A couple years ago, I wouldn't have supported a piece of legislation like this, and I'm coming around to that, so you might get my vote on this. But the question, I'm trying to get the scope of the bill.
Sure.
Is this saying if you're an ex-felon, you've done your sentence, you get out, and then you can get your voting privileges back?
Yes.
In addition to that, is parole and probation also considered to get your voting rights back?
No, I'm striking that.
Okay. Because I was going going to say, I think we need to have the dialogue if we still have the punishment in there.
See, that's the problem. They can definitely vote. Once they're released, they've served their sentence. Probation and parole doesn't have anything to do, and most of the time, the crime that they're convicted of has nothing and no association to voting.
Right, and that's where I'm actually coming around to
Right.
that point. But-
Additionally, many people don't understand that when you're young, you do things, your judgment is not that of when we gracefully mature. But what happens to many individuals is when they're young and appear before the judicial system, a lot of them take plea bargain, not knowing that when they take that plea, you can't appeal it. And then they get a felony conviction, not knowing that they can't vote. So, you know, a lot of those felony convictions is because of mostly, and it's unfortunate, and we were talking about this in reference to expungements. Everybody knows that there is a huge disparity with ethnic minorities. And the largest disparity is with African American males, okay? The second largest disparity is with Hispanic males. So we all know because of those disparities, they get different charges because there's some disparities in our judicial system. Hopefully we're getting there. In my opinion, we have not arrived to the point that we need to be. But many of those convictions are plea bargains. You know, you're young, you're afraid. I personally know an individual, and they said to me, and this is an involuntary manslaughter, they took the plea. I was like, no, don't take the plea. See, I'm going down fighting from day one. Everybody knows that. I'm going to go down fighting. I am not going to arbitrarily agree to anything that I did not do. This young man said, but if I don't, I get 10 years if I get convicted. I'm going to take the plea. Don't take the plea. Don't take it. Well, he got a felony conviction, and everybody knew because at the time that he decided that he was going to take the plea, prior to that, based on the information that they had, he decided that he was going to tell them that he was driving. And there wasn't involuntary manslaughter because the best friend died. He died. But the best friend was the one that was driving, and when they were all hospitalized and they were questioning everybody and nobody would say who was driving. And because he knew that his best friend had some other convictions and he had none, he said, I don't remember, maybe I was driving. So on that basis, they decided to convict him of involuntary manslaughter. Okay? So that's just one example of how we get charged. You know, the young people don't understand it. They don't understand that, hey, once I take this plea, misdemeanor, felony, I can never, ever appeal it. And then that, based on the fact that he decided to say that he was driving, did not know at the time that his best friend was hospitalized and had died because he did not want him to have another charge. This individual took it. So for over 10 years, he's a felon, he has a felony conviction, and can't vote.
I was just saying you probably have an unlikely supporter from me.
Really appreciate it.
And another thing is I sat on JPR for 4 years.
I
And
know
it
you
seems
did.
like everybody wants to make everything a felon these days.
Exactly.
So we're getting so much caught up in what a felony is. So.
No, I appreciate your support, Senator Simonier.
So that was a 4-year sentence on JPR?
They tried to give him another sentence, but he wouldn't leave me. Any further questions, committee? All right. Thank you so very much. Thank you for your testimony. Thank you for your participation. No. Thomas Lopez spoke. There's Mr. Lopez right there. The only person that I have not heard from is Adrian Muldrow. Okay. All right. Thank you, Jane. That concludes the hearing.
Madam Chair,
Sure.
I just want to say, for Get Money Out, I inadvertently forgot to sign up, and all I want to say is we support the bill. We don't see what these convictions have to do with voting. So,
Okay,
the game's
thank-
written, but I forgot to sign the sheet.
Thank you, Charlie. Yes, yes, I'm sorry, Senator Bates.
Question about the fiscal note. It says general fund expenditures to increase. It says, and transportation trust fund? Increase?
I don't know why the Transportation Trust Fund, I kind of looked at Transportation Trust Fund, but I did have one question. Linda, and I could have talked to your assistant. I really know, I think the bill actually says that you need to contact Department of Corrections, and I think we probably need to amend that because the Department of Corrections need to be in collaboration with you in terms of submitting the discharged individuals to the state election board, and at which point you will send it to the locals. All right, don't talk to each other, talk to me. We're trying to make it easy and make it a seamless process in terms of how do they know that okay, I can tell an individual upon discharge that, okay, your voting rights are restored. We could even tell them, but then you don't have the list.
But if they fill out the voter registration application, we'll get that from the Department of Corrections.
Okay. So in the past, so you wouldn't know anyway whether or not they finished their probation or parole, right?
No, and that's part of the problem with the current law.
And that's what I said.
Right.
So, okay, I can strike it. We will amend it out because I was still under the impression that when we did the last bill, and I think I told some of the members the same thing, that although the bill says that they must complete probation, parole, and/or restitution, it was always my understanding that the Board of Elections had no capacity to figure out or find out that information.
That's correct.
All right. I just want to make sure it was the same.
And just a suggestion, make the bill effective June 30th, and
Sure.
that'll take out some of the fiscal note because we have to reproduce our voter registration applications this summer, and we'd have to do another printing of it after the bill became.
October. So, okay, we'll change it, and then we will take you out as being the responsible one. All we'll tell them is fill out their voter registration.
Correct.
Because I thought when we had this long and detailed discussion that you had no way to actually determine whether or not they had finished their probation and parole.
Exactly.
All right, thank you
you.
much.
Thank you.
All righty. June 30th.
Yep.
Yes.
All right, thank you much. Bye-bye. All right, we're going to do 343 very quickly. It's the advisory opinions and informal advice. Mr. Lloyd, you want to come forth? Okay, and I think the problem has been this. Whenever the Ethics Commission or anybody gives advisory advice, it's considered an opinion, and we don't necessarily need it to be considered an opinion if, in fact, it's advice and advice only, which means it's informal. And it's not subject to public requirements, okay, for advisory opinions. That's all I have to say. Mr. Lloyd, you want to give him the particulars?
Thank you, Madam Chair. Michael Lord, Executive Director of the State Ethics Commission. Our written testimony, I think, spells it out pretty clearly, so just very briefly. We already provide this informal type of advice that this law seeks to, or that this bill seeks to put into the law. We do it under regulations that have been adopted by the Commission pursuant to other authority in the law. So the Commission is simply looking to take current practice and have it formally and officially adopted into the law. And we do it we provide advice informally because the volume of requests we're getting is just so great that if we did it in a formal advisory opinion mode like the law provides for, we would be swamped. We've done 500 formal advisory opinions during the course of the Commission's history. We do 500 a year now of informal advice, and so we're simply looking for recognition in the law. We believe we've been doing it properly for 20-plus years under regulations, under authority we have in regulation, but it just is a better practice in our view to put this into the law and recognize the informal advice, maintain the confidentiality that the law provides for, because without confidentiality, people aren't going to come to us. We want people to come to us before they violate the law, and so that we put them on the right course, so that we don't have to deal with them as an enforcement matter. It's good public policy. And with that, I'm happy to answer any questions.
Senator Kagan.
I don't have noise yet. Am I on? There we go.
Yes, you are.
Over the years, I mean, back with Bill Somerville and now with Dia Daly, I know that I've sought informal advice many times. My question is, I see that the effective date is July 1st. I'm just wondering whether that will cover retroactively, or what would happen if one of us came to you all next week or between now and July 1st?
Well, our regulations already treat it as confidential. And there are provisions in regulation that the Joint Committee uses that treat it as confidential. So it's not like it's adding, it's simply putting into the law what's already authorized in our regulations. We treat every piece of advice we give as confidential. And so if you came to, well, if you came to us for some financial disclosure advice next week, we would treat it as confidential as per our regulation. And as I said, we're simply looking for a formal recognition that this process and the confidentiality that goes with it is found in the law.
So to clarify, you're basically then codifying current behavior?
Current behavior as authorized in our regulation, and our regulations are enacted pursuant to what the law says we can do. But we'd just like to put it in the law and make it clearly recognized there.
Okay. More explicit.
That's all it is. It's just to be explicit so that we can point to the law and say the law says it very explicitly right here.
Okay. Thank you.
You're welcome, Senator.
Any further questions of Mr. Lloyd? If not,
Thank you, Madam Chair.
that concludes the hearing. Thank you. We're moving on to Senate Bill 350, Veteran-Owned Small Business Enterprises Participation Goals. Senator Edwards, welcome.
Thank you, Madam Chair.
You also have Ms. Chris Hale and Christopher Eccleston.
Program from 0.5% to 5% of the total value of the procurement contracts. If you read the fiscal note, you'll see that very few have been issued, and so you would say, well, why would you raise it? Well, this actually passed in 2010. Didn't really go into effect till July 1st of 2012. And since then, there's been a lot of veterans return from overseas. So you have a lot more of them probably owning small businesses. And therefore, hopefully we'll get involved in the program. And hopefully the administration and the Veterans Secretary will work to get them involved. So would ask that you support this. If you can't support going to 5%, at least nudge it up a little bit to have some cushion there to those who want to participate in the future, that we can get more involvement from veteran-owned businesses, small businesses. So I would appreciate your support of the bill. That's it.
All right. I call Mr. Chris Hale and Christopher Eccleston. They're all in favor of the bill, and then you have Isla Hopkins, favorable written only, and Scott, I think it's, what's that, Knudsen, information.
I think some of them got snowed out, Madam Chair, because
Okay.
one or two were coming from the Eastern Shore, and I think they probably got snowed in
Not a
or
problem.
out, one or the other.
I just wanted you to know that they're favorable, Senator.
Thank you.
Okay. Is there any questions of the bill sponsor? You must have done an excellent job.
Thank you very
They
kindly.
always have questions. Thank you.
Have a good day.
You too.
Thank you.
All right, we have Senate Joint 2, United States Constitution Amendments to the Convention Democracy Amendment. Senator Pinsky, and you have a panel. Patrick S. Enright, Professor Richard Strainer, Wiley Burge, Herb Ethel.
Wiley's on his way.
Okay. Sabrina Williams.
She had to go home.
Okay. David Ladd and Alan Hyman.
Thank you, Madam Chair. Sure. And as we spoke, I believe there's no opposition to this.
No.
So the people testifying will be concise and to the point. We don't want to ruin a good thing.
There you go.
Madam Chair, members of the committee, Senate Joint Resolution 2 is called the Democracy Resolution, and it deals with the issue of private money in politics. If you go back to 1974 in Buckley v. Vallejo, where they said trying to limit expenditures, private expenditures on campaigns, was against the Constitution, was unconstitutional because it abridged free speech. They equated free speech and money. And then 2010, the Citizens United case and the McCutcheon case. Now, for all intents and purposes, at the federal level and to some degree at the state level, money is free-flowing. There are no limits anymore. I know many of us don't like raising money. We start to see sums of money either federally with a presidential race or congressional races or our own races starting to go through the roof, or not starting to go through the roof, continuing to go through the roof. And it's not anything I think we want to spend our lives doing. We want to talk about policy and moving the state in the correct direction. Unfortunately, there are very few avenues to limit money since the Supreme Court has spoken, and it is unlikely that Congress in the near future will be willing to act or in any kind of functional way able to act. So what this resolution, this joint resolution does, it follows the Constitution, Bill of Rights, in terms of amending it, which calls for, to do such a thing, you need 2/3 of the states to call for a constitutional convention so this issue can be taken up. Some say, is this sending a message? Do you expect it to happen? You know, when's the last time it happened? You know, I get these questions all the time. And regardless, it's an honest attempt to address an issue that is out of control. We saw one major fundraiser, Koch brothers, they pledged, I don't know, $1 billion over future years in terms of raising money. We know how much it costs to run for president of the United States or to run for Congress. People have to raise $1 million to $2 million a week for a position that's $160,000, $170,000 a year. So this resolution would have us join and be one of those states that has agreed to be among those 2/3 that are needed to actually have a constitutional convention to once and for all address the issue of unlimited private spending on elections. This committee passed this last session. I am hoping we do it again. And with that, I will keep my comments short. In fact, I will end them and pass it on to my next person. Yes.
Madam Chair, members of the committee, my name is Richard Striner. I'm professor of history at Washington College. I will be brief. I'm here to talk about history, not only history in the past sense, but in the chance that you all have to make history on the grand scale. In 1857, the Supreme Court handed down, in the Dred Scott case, a decision that many, including Abraham Lincoln, condemned as absurd. Abraham Lincoln pledged to pay no attention to the Dred Scott decision, and in his first inaugural address, he had some pithy things to say about the Supreme Court's claimed right to be the final arbiter of constitutionality. The Dred Scott decision was finally nullified by constitutional amendment, the 13th Amendment, passed by Congress and ratified by 3/4 of the states in 1865. The problem with a written constitution, one problem, is that people read it differently. The Founding Fathers themselves disagreed at times severely with regard to the meaning of the Constitution. The participants at the Constitutional Convention famously disagreed. Some Founding Fathers opposed the ratification of the Constitution. They were anti-federalists. In the presidential administration of George Washington, Alexander Hamilton urged Congress to create a Bank of the United States. James Madison said that's unconstitutional. George Washington, who chaired the Constitutional Convention, had to make up his mind whether it was constitutional or not. Congress created the bank with a 20-year charter. It lapsed in 1811. When the bank came up for recharter in 1816, James Madison, who had called it unconstitutional, changed his mind and decided that it was constitutional. He supported it. And so it goes. So it has gone down the years, and so it will continue to go, because words can sometimes be ambiguous. As every lawyer in the room knows, the law must be construed. In this particular case, it is necessary to clarify the text of the Constitution, specifically the First Amendment, as cited by the Supreme Court in the Citizens United decision. All this is history past extending into the present and future. But on another level, and I leave it to my colleagues to discuss the merits of the issue of regulating campaign contributions, this particular provision inserted in Article 5 by the Founding Fathers, whereby when and if 2/3 of the legislatures of the states direct Congress to call a convention for the purpose of drafting a constitutional amendment, if this were to take place now, it would be the first time in American history that this particular provision of the Founding Fathers' Constitution was fully utilized. And in my judgment, this would take our American democracy across a profound threshold. It would be a profoundly beneficial thing for our American democracy if this were to happen for the first time. I've promised to be brief. I will cease my remarks now and answer any questions if you have them.
All right.
Next.
Madam Chair, members of the committee, my name is Wiley Burge, and I'm a professional musician. So I'm an expert on Fender guitars, 50s and 60s rock and roll, and choosing the right song for a particular group of people. Since I started paying attention, I've grown increasingly concerned with the growing influence of money in politics. So much so that I've decided to volunteer a large amount of my spare time to be part of the solution. I'm the vice president of Get Money Out, and throughout my work I've become a bit of an expert on campaign finance reform, at least among my peers. One thing I'm not an expert on is Latin. So when the Supreme Court said their definition of corruption is limited to quid pro quo corruption, I of course understood what they meant, but I wanted to look up the direct translation of the phrase. It translates to something for something. Other similar phrases include give and take, tit for tat, I'll scratch your back and you'll scratch mine. I'll drop a big bag of money directly on each of your desks, and you'll pass a bill directly through this committee that will require all guitar players in Maryland whose names start with W to be the first choice on any gig. We know that this definition is much too narrow, and what we have in the federal government is not necessarily corrupt politicians or corrupt lobbyists, but a system that is corrupt and does not serve and represent the average American's interests. When common sense limits to campaign spending are not in place, elections become much less about who has a better plan to tackle the issues and much more about fundraising and running the most effective ads. Regardless of which candidate wins, the money almost always wins, which is why it's not unusual for wealthy businessmen or corporations to give to both parties or multiple candidates in a primary. Even if the candidate with the most money doesn't win, all candidates for federal office have to have a large amount of cash, directly or indirectly, to have a chance. Not that this system is necessarily great for corporations either. The status quo, that's another Latin term for you, the status quo also allows for a system in which politicians are able to extract competing money from businesses that are on opposite sides of an issue. And the donations from Google versus AT&T on net neutrality is a recent example of this. This is yet another situation that causes money to trump the interest of the public. Larry Lessig of Harvard Law put it well in his recent book, Republic Lost. The current system of campaign funding radically benefits the status quo for private interests and the status quo of the fundraising Congress. I'm before you today to fight for a status quo that benefits average Americans.
Okay, I'm Herb Edel, also on the board of Get Money Out Maryland. And first, we greatly appreciate each of you for holding these open hearings, listening to citizens' concerns, and we hope acting quickly and decisively to resolve this crisis. Get Money Out is a 100% volunteer local nonprofit with about 1,200 supporters across Maryland in nearly every district, including 4 who drove here from Frederick and Washington counties today. I hope you can hear and can raise your hands, okay, and other parts of our state. Our goals in educational work are supported by more than a dozen Maryland groups. Our main national affiliate is the Wolfpack Network, which currently assists campaigns seeking to pass parallel resolutions in 24 states, including 3 that passed it in 2014, California, Vermont, and Illinois, plus New Jersey that just passed it this week. Maryland should be the 5th and join them. This fast-growing movement spans all parties, ideologies, and age groups, from older folks who remember or are concerned about the erosion of the democracy that we all took for granted, to millennials and younger, who tragically will inherit the plutocracy that America is rapidly becoming, unless we move quickly to reverse this. Former moderate President Carter recently lamented, quote, "America does not at this time have a functioning democracy." 6 decades ago, our President Eisenhower recommended the very solution we now seek in reminding us, quote, "Through the state legislatures, the people can demand conventions to propose amendments to reverse trends they see as fatal to true representative government." Friends, that time is now, and we must seize this moment before it's too late. The mission falls to our state legislators, you, who are far more accessible than Congress. As Americans all know, it's time we all rise above our other differences and join together to strike at the root of this crisis and embrace what may well be the only long-term systemic solution to restore the inclusive, responsive, and accountable America all our people need and deserve. The members and supporters of Get Money Out Maryland, those here and over 1,000 more who could not come today, urge your favorable report on SJ2. Thank you.
Thank you. Senator Young, followed by Senator Rosepap, has a question.
Senator Raskin, and then take questions.
Oh, I'm sorry. Sure.
Thank you, Madam Chair. I'll be quick. But I just want to emphasize first that there are 2 parts to this call that's spreading across the country for a constitutional amendment on the right to vote and on Citizens United. The first part is to reaffirm the right to vote, which has always been in peril in American history, and largely because we don't have explicit constitutional language that protects every citizen's right to vote. The other part deals with the Citizens United decision. Let me just say a word about each of these. When you interview Americans, most people think that there is a constitutional right to vote. And that's because we have a whole sequence of constitutional amendments that prohibit discrimination on a certain basis. So the 15th Amendment says you can't discriminate on the basis of race. The 19th Amendment says you can't discriminate on the basis of sex in voting. The 24th Amendment says you can't interfere with the right to vote based on a poll tax. The 26th Amendment says you can't discriminate against the right to vote against people who've already turned 18. So people assume there is a right to vote, but the problem is that, in fact, there are lots of disenfranchised populations. For example, as we know, ex-felons. Now, we largely re-enfranchised ex-felons several years ago, and most states have done it, but there's still about 10 states where ex-felons can vote, and they brought a Supreme Court case on the logic of the right to vote, and the court simply came back and said, under the 14th Amendment Equal Protection Clause, you don't have a right to vote. And we know that there are other disenfranchised populations. For example, people down the road in Washington, D.C. have no voting representation in Congress. They brought a lawsuit called Alexander versus Daly, and the courts told them you'd be right if there were a constitutional right to vote and be represented, but there's not. It belongs only to people within the states. They can't be discriminated against in certain kinds of contexts under certain circumstances. Over the weekend, the Executive Committee of the Democratic National Committee approved a resolution introduced by Donna Brazile calling for a constitutional amendment on the right to vote to deal with a whole series of assaults on the right to vote across the country, and a lot of confusion and unclarity about whether people have that right as against certain kinds of voter ID, photo identification, and so on. So that's the first part of what this resolution calls for. It's clarifying and establishing that everybody's got a right to vote. And the other part deals with the problem of Citizens United, where the Supreme Court overturned basically 2 centuries of understanding of what a corporation is. It had always been seen as an artificial economic entity chartered for economic purposes to do business. And suddenly the Supreme Court said, for political purposes, it's also an association of citizens. Now, you looked at a bill that I introduced saying, well, if that's true, if the corporation's just speaking for the shareholders in politics, they should have the right to vote on it, and there should be disclosure, and that's something we can deal with at the statutory level. But the broader problem is something that does require constitutional correction, because the Supreme Court has basically bulldozed the wall of separation between corporate treasury wealth and public elections. And that's a wall that existed for many, many decades in federal law. And in fact, it still exists to the extent that a corporation cannot now give a contribution directly to a candidate, although, of course, under the logic of Citizens United, that's going to be the next restriction to go. If a corporation has the First Amendment political rights of the people, they should be able to give directly to candidates. And, of course, that's what James Bopp and the other lawyers who brought the Citizens United case are now arguing, that there should be no controls against what kind of involvement the corporations have in our politics. So our position is we go one way or the other. Either you go with them and you say, okay, corporations really do have all the political rights of the people, or else we reestablish the wall of separation between corporations and elections.
Thank you. Senator Young, followed by Senator Roseback.
Is this word for word the bill that's passed in the other states?
No.
It's not word for word, but we are working off a draft, and they are very similar.
Can you tell me what the differences are?
It's my understanding some of the whereases might be phrased a little differently. But the call for the Constitutional Convention on voting rights and Citizens United, I think, is included in all of them.
Is there anything else included in any of the others?
No, there's nothing additional included in them. They all have to do with the issue of money in politics.
Okay. I want to vote for the bill. I just get nervous about this becoming a runaway convention, and even down in one of the whereases, it does refer to the above, but it says that the legislature can expand, restrict or expand the power of the delegates.
Yeah, I think I understand that, but if you look on page 2, the second resolved, line 35 to 37, as much as legally possible, trying to narrow the charge to address that concern of a runaway convention. That's been a concern and fear that's been raised by some people.
Yeah, that's my fear.
Understood.
You say as much as legally possible we're restricting. Is there a case that we can't legally restrict it?
Well, we don't have a lot of case history here. Yeah. It's my understanding that attorney said this is as close as you can get to narrowing the focus of any potential constitutional convention. I mean, clearly, we need 2/3 of the states to do this, and I think everyone agrees either this picks up a national conversation about money in politics, and that it becomes focused.
Yeah, I want that. I've just had some really crazy amendments proposed to me by people that I wouldn't want to see happen.
Understood.
If we did this.
I would assume this will get farther than any of those.
Senator Roseback.
Philadelphia is we're here, we can do it. So I'm not clear why, well, first of all, there's that question. Let me relate the two to each other. Given that concern, which obviously others have, and this is not a new question you've gotten. Given that concern, what is the advantage of pursuing a constitutional convention as opposed to just pursuing directly constitutional amendments under the amending power in the Constitution?
The issue you raise is cogent. What the Founding Fathers did in Philadelphia in 1787 was comparable to what Thomas Jefferson would do in 1803 with the Louisiana Purchase. There was some doubt as to whether the purchase of territory to augment the size of the Union was itself constitutional. And as a strict constructionist, Thomas Jefferson agonized maybe for about 10 seconds. And then he signed the treaty, sent it to the Senate for consideration, and said, in essence, if I've made a mistake, stop me. What happened in Philadelphia in 1787 is that the Confederation Congress summoned a convention to draft amendments to the Articles of Confederation. The leaders of the Constitutional Convention decided for a number of reasons that the Articles of Confederation were unfixable, completely hopeless. They decided to exceed their charge, but they stipulated that when they sent the draft Constitution back to the Confederation Congress for their consideration as to whether it would be sent out to the states for ratification, per the ratification procedure spelled out in the newly drafted Constitution, the Confederation Congress would have to weigh and decide whether that convention chaired by George Washington had in fact gone too far. The Confederation Congress decided that the Constitutional Convention did the right thing, and they sent it out. There is no perfect and pristine method in some cases. With regard to this procedure now, I'm not speaking as a historian so much as a citizen who supports this bill. Given the fact that I think we are in a profound civic crisis in the aftermath of Citizens United. All right then. Given the fact that it seems to me unlikely for the foreseeable future that Congress, by supermajority vote in each House, will draft the kind of amendment we need, it seems to me that we need action at the state level all over this country to supply that kind of necessary pressure. And weighing the issues pro and con, I've weighed them for about 10 seconds, and I've decided this is something we should do.
I should, or certainly as well as you do. I thought there was also a provision for states to initiate a constitutional amendment. Is that wrong?
That is this provision.
Is the only way that states can initiate a constitutional amendment is through a constitutional convention?
That's what Article 5 stipulates.
Okay, so that's really the technical answer to my question. In effect, is the
Yes,
advantage of doing this is it allows you to get around the supermajority requirements in the Congress.
Right. The advantage is you. You know, everybody in this room on the state level.
I'm flattered.
Right.
But no, seriously, I mean, that really is the technical advantage here, is you get around the supermajority requirements for Congress to initiate a constitutional
It
amendment?
forces the hand of Congress. Alexander Hamilton said as much in Federalist Number 85.
Okay.
You remember that, don't you?
Yeah, you know that better than I do. But seriously, I mean, is that the case? It's about the numbers in Congress? Is my
It's
statement
about
true as well
forcing-
as Alexander Hamilton's?
It's about forcing action.
But is it because of the numerical requirements in the Constitution for supermajorities for proposing constitutional amendments? That's what I'm asking.
It's because we don't have to ask the impossible, which is asking Congress to pass a bill. That's why we want to do it this way.
That's right.
Okay, thank you.
I'd also just like to add real quick, which is just...
No, very
Sure.
quickly. No.
Sure.
Senator Bates.
Two questions first. First of all, how many states have done this? Four so far. And does it have to be in exactly the same language, or can be generic enough?
The topic has to be the same, and something historic has happened recently in the last couple of weeks, and that is you can look on the website of Congress, and they've actually started counting these resolutions for the first time, and you can see very clearly that all four of those are in what's called the same pile. So they're organizing them in different piles concerned with topics. And there's a pile that has to do with our topic, which is money and politics, and that has these four resolutions in it. And there are many other calls all throughout history, and those are all in all different piles.
Right. I was going to say, I know I've been hearing of other calls for Article 5 Convention of the States. Radio talk show guy Mark Levin has been calling for that as well. I don't know what the status of his is, but I do understand that there's at least, one or more others. Okay, thank you.
You're welcome. Senator Montgomery?
Constitutional lawyer, could you explain to me that when slavery was overturned, I realize that took a war, but when women were given the right to vote, and when we had prohibition, and we no longer do, what was the legal process that was done to change that? There were no constitutional conventions to do that. So would you help me learn more about my own government by explaining that to me, because it seems to me this is a very hard way to change something that definitely needs changing.
In each case, Congress, by supermajority vote in each House, drafted the constitutional amendment, and the amendment was sent out to the states for ratification by a supermajority of 3/4. But in several cases, there had been campaigns from the state legislatures to call for an Article 5 convention. And in the case of the 17th Amendment, there is historical reason to believe that it was this mounting pressure from the states that caused leaders in Congress to say, we better draft this, because if we don't, somebody else will.
Thank you very much for that information. It still seems to me this is one approach that maybe we could begin to use a double-edged approach to this, to do both that and also this constitutional convention. I share the concerns of my colleague across the aisle that this could also get run away with and perhaps not achieve what we might be asking for now.
Senator Warren, followed by Senator Kagan.
Thank you, Madam Chair. All right, Professor, the Article 5 convention, if convened, is limited in scope. How? Because as I read Article 5, there's no indication that there's any limit in scope.
Interestingly, and this is an illustration of the very problem that from which much of this situation derives. The federal Constitution in Article 5 does not clearly spell out a lot of the details. This would be an experiment, an innovation in the evolution of American democratic institutions. I personally am not excessively worried about a runaway convention because any amendment emanating from it would have to be ratified by a supermajority of three-quarters of the states.
Okay. And in 1787, when the states decided to convene a constitutional convention to nibble around the edges of the Articles of Confederation, what happened?
Well, as soon as the Constitutional Convention met in Philadelphia, they decided several things. First of all, they decided to close their doors. They decided to embargo the notes of the convention for 50 years. And then they decided that the Articles of Confederation were hopeless because the amendment process within the Articles stipulated that every single state would have to ratify an amendment. So after all that work, if one state declined to ratify, the whole effort would have been for nothing. That's why the Constitutional Convention decided that in the ratification procedure for the Constitution they were drafting, three-quarters would have to ratify.
Okay. And if we have an Article 5 convention, what is the representation that goes to that as a voting empowered member?
That, it seems to me, would be up for the legislatures of the states to determine. You all would have a tremendous degree of discretion in deciding exactly how this process would unfold.
Okay. So we don't know who would go. We don't know how much of a vote we would get. We don't really know what they would do, but we're pretty sure they would do something.
It's an election, or it's either by election or you all vote who goes. It's
Again,
not.
I would say it is up to you all to stipulate that. You have that power.
Right, but we're one of 50 states.
Quite right.
Got it. Thank you.
Senator Kagan.
Thank you, Madam Chair. Before I ask my question, Wiley, loved your testimony, and I love that you're here. Music and politics go together beautifully. I'm deeply involved in both, and so
Thank you.
rock on, keep going. Dr. Striner,
Yes, ma'am.
I wonder, I had two questions, both related to timing. First off, in this joint resolution, I don't see an effective date or a date by which all of our folks need to get a copy of the joint resolution, and I don't know if I'm missing that. But my primary question is about how long it would be valid. Can it stay in perpetuity, our request, until such time as an adequate number of states request a convention? And I guess that's also, and I know we started it the opposite way with the Equal Rights Amendment, and there it started in Congress and went to the states, but there was a deadline, and then some states rescinded their request. So if you could just speak to both of those kind of concepts about timing, expiration date, rescissions.
Those are excellent questions, and I have to confess candidly that I don't know the answer, but several others in this group very well might.
Okay. Thank you, Doctor. Thank you, Madam Chair.
Okay, this panel is done. Okay, you have another panel. Thank you very much. David Ladd, Alan Hyman, Susan Ogden, Bob Golden, Charlie Cooper, Brian Clayton, Charlie Carter.
Madam Chair, do you have Patrick Enright on that list?
Whom? Patrick Enright?
Yes, ma'am.
Yes.
And Larry Stack?
Do you want to go?
Yeah. But Larry is further down, but if you all fit, it's fine with me. So, okay, start off by giving us your name and begin your testimony.
Madam Chairwoman, my name is Ryan Clayton. I'm the Executive Director of Wolfpack, which is the political arm of the Young Turks, the largest online news show in the world. First of all, thank you, Chairwoman, and members of the committee for having us here today for this hearing on this most important matter. We know you have a lot of important things before you, and we appreciate you taking the time to address this issue. We're currently working with volunteers in 40 states to pass resolutions at the state level calling for an amendments convention to restore free and fair elections, and we'll have 20 resolutions like SJ2 live this year, and recently passed similar resolutions in Vermont, California, Illinois, and New Jersey. With another organization I was involved with, we asked 2 United States representatives and a United States senator, said, what can we do for you? Not, can you give us this thing or will you vote this way? We asked them an open-ended question and said, what can we do for you? And in 3 separate meetings, totally uncoordinated, they all had the same answer. They said, free us from fundraising. Free us from fundraising. President Madison said in the Federalist Papers that the federal government should be dependent upon the people alone. And President Jefferson once said, the same is true today as it has been throughout all history, whether men shall be allowed to govern themselves or be ruled by a small elite. And when donors, not voters, choose who is elected to Congress, we are in danger of once again being ruled by a small elite. But I don't believe that's our fate as a country. I don't believe a rebirth of aristocracy is where we're headed. I believe a rebirth of representative democracy is on our horizon. And every American here in this committee room, every citizen in the state of Maryland, and every citizen in this country knows that elections should be free from the corrupting influence of excessive spending by outside interests, and fair enough that any citizen can run for public office, not just millionaires and billionaires and their buddies. That's not the case as it stands today, where candidates for Congress have to spend 5 to 7 hours a day, 5 to 7 days a week raising money from rich people. That's not the way it's supposed to be. How many good people with great ideas do we miss sending to Washington because they refuse to become professional telemarketers, dialing for dollars every day? The good news is that we can fix this. Just like every other generation of Americans, we can amend the Constitution to make America more democratic, more inclusive, and a more perfect union. We must amend because the Supreme Court has taken a wrecking ball to the wall of separation between wealth and state, handing down decision after decision that destroys federal campaign finance regulation, most notably with Citizens United versus FEC, but also refusing to hear states' objections to interference in their own elections, such as with American Tradition Partnership versus Bullock. So no law passed at the state or the federal level can be protected without an amendment to the Constitution. And there's 2 ways to amend. 2/3 of Congress can vote to propose an amendment, or 2/3 of the states can demand a convention to propose amendments. And either way it's proposed, 75% of the state legislatures, 38 states, must vote in favor of ratification. And looking at history, most amendments start with state legislatures taking action and passing calls for an amendment through a convention. 4 out of the last 10 amendments started at the state level and then were proposed by Congress. The Bill of Rights began when New York and Virginia called for a convention to propose those amendments, and most notably, the 17th Amendment got within one or two states of compelling a convention, and then and only then did Congress capitulate, proposing the amendment for the direct election of senators. So historically, there's over 700 applications on a variety of issues for a convention of the states. 49 of the states, including Maryland, have passed previous resolutions calling for an amendments convention. And this is how we know that only resolutions on the same issue will be counted together toward an application. And therefore, that means the scope of the convention will be limited to the specific subject matter stated in the state's application. If you could take 10 resolutions from issue A and 20 resolutions from issue B and 5 from issue C, and then count them together and hold a 3-issue convention, well, Congress can do that tomorrow. But they don't do that, because what they do is they count them together only on the same issue. There's a very strong precedent for a single issue convention. And furthermore, there have been over 233 state-level conventions to amend and adapt their constitutions. None have ever exceeded the scope of their mandate. 0 runaways. But the same reason that some groups and individuals oppose the convention process, such as the John Birch Society, it's the same reason I'm for it. It's a democratic process. You get people together from across the perspectives and ideological lines. You assume nobody has a monopoly on the truth. You discuss and you debate ideas. You distill and synthesize those ideas into a proposed solution, and you send that out to the population for ratification. And if they want it in the Constitution, if 38 states want it in the Constitution, then it's included. And that's how democracy is supposed to work in this country.
Mr. Clayton, we're going to have to wrap it up.
For sure. We've never solved any problem in America with less democracy, but we have solved some pretty serious problems by amending the Constitution. Every generation has amended the Constitution, except for ours. And now it's our turn. So thank you for your vote and your consideration in favor of SJ2. Thank you for being leaders in the fight for free and fair elections. And if you have any of the questions you were asking earlier, I can help to address those.
Thank you. And I hate to do this to supporters of my bill, but fairness is fairness is fairness. We have a number of bills behind us, too. So if you can keep it to 2 minutes or maybe 2.5 at the most, I think we have to respect the other people and other bills as well. With that, the next, whoever that might be, Charlie.
All right, so I will keep this under 2 minutes. So I appreciate the opportunity to testify on this Stafford. I'm representing Progressive Maryland. We're a grassroots organization of progressives from all across the state. And SJ2, it simply asks Congress for an amendment, for an amendments convention to be called pursuant to Article 5 of the U.S. Constitution. As soon as 2/3 of the states have applied for a convention, the purpose of the convention would be to move forward an amendment to the U.S. Constitution to affirm every citizen's freedom to vote and restore free and fair elections in America. Vermont, California, Illinois, and New Jersey have already passed resolutions calling for amendments for an amendments convention. At least 14 resolutions were proposed in the 113th Congress to address the disastrous Citizens United decision. The language differs a bit, especially regarding corporate personhood. Some don't address it, and those that do would eliminate that fiction by limiting a broad or narrow range of rights to natural persons. Most relate to contributions to or electioneering for or against candidates for office, federal, state, and local. Some also limit spending on ballot questions. Many indirectly break the connection between free speech and monetary contributions by explicitly permitting regulation, but only one, the Nolan Resolution, directly states that money is not speech. Nevertheless, none of the 14 would counter the growing threats to the Voting Rights Act, nor effectively resolve the triple problems of Citizens United, corporate personhood, and unlimited corporate spending and elections, as SJ2 would. More to the point, none of these have been nor will be acted upon. The resolutions are not even being heard. Indeed, Congress has proven unable to pass even a reform as modest and as obvious as the Disclose Act. And so that's why it's our responsibility here at the state level to take this on. Congress is not taking this issue on and not able to move on it, and so the states can take it on. So I'll keep it to that.
Thank you. Thank you, Ms. Stafford. Ms. Carter, are you next?
Thank you, and I will be brief. My name is Charlie Carter. I'm Executive Director of Maryland Working Families, here to voice my support for SJ2. On a national level, Working Families Organization is a leader in campaign finance reform, and that's why I'm here today. Maryland Working Families is an independent political organization that fights for policies that support dignity and justice for working families, communities of color, and the unemployed. Our affiliates represent some 100,000 voters in the state, in addition to our base of 30,000 independent supporters. Ensuring that all residents have an equal opportunity to participate in Maryland's economy and democracy is at the heart of the work we do. We're all familiar with the saying, money talks. What we've learned since the Supreme Court's decision on Citizens United is that money's voice is loudest in our political system. The impact of their decision has reverberated across the country as those without the means to make their voices heard are silenced, and it raises serious questions about a form of government that is based on the premise that all men are created equal. Since the 2010 Citizens United decision, the amount of money in politics has increased exponentially, while donor identity and contribution source have become ever more shrouded. Not surprisingly, during the same span of time, we've seen an increased attack on working families, especially the working poor. This comes in the form of budget cuts to safety net programs and public education, rolling back of business regulations and oversight designed to protect consumers and the environment, selling of public resources and infrastructure to for-profit corporations, and full-on frontal assault on pensions, wages, collective bargaining, and working conditions. Is there any wonder that less than 45% of the state's registered voters went to the polls on Election Day last year? And that is the lowest reported percentage of voter turnout for any general election since the information has been published on the state website. There's a direct correlation between the rise of money in politics and the decline in voter participation. According to a 2012 Brennan Center study, 1 in 4 Americans say they are less likely to vote because big donors to super PACs have so much more influence over elected officials than average Americans. It's also worth pointing out that there's the negative impact of Citizens United has not been limited to the working poor. A recent study by the Carey School of Business at Arizona State University found that firms with corporate treasuries large enough to make regular political contributions experience lower and more consistent effective tax rates in the long run. Conversely, most small business owners that don't have time to spend money on politics and are increasingly worried about their growing exclusion from the political process. For this reason, we ask you for a favorable report on this bill. Thank you.
Thank you, Ms. Carter. Next.
Susan Ogden, Maryland Committee to Amend. I want to follow up on the idea that Congress has become a body of fundraising telemarketers. It costs over $10 million to run for Senate. It costs over $1.7 million for a congressional seat. This fundraising that's required by these sums is negatively impacting our democracy. Senator Tom Harkin, who just recently retired, has stated, Congress doesn't work because we fundraise way too much. Senator Dick Durbin has said most Americans would be shocked at the amount of time we spend thinking about raising money, talking about raising money, planning on raising money, and raising money. And we have to go across the street to non-government offices to raise this money. Essentially, we are high-priced, highly paid telemarketers who are then beholden to our big donor and corporate interests. How is this impacting our democracy? There can't possibly be as much diversity that represents America in our Congress today. Who can afford this fantastically expensive way to get to Congress? The potential and current members turn to the big donors because it's easy. One call for $10,000 versus 100 calls for 100, you can see where the math goes. Most of these big donors aren't even voting in the congressional district. They're K Street lobbyists. Some of them are international entities, and that should give most of us real pause about that level of influence. Knowledge is one catastrophe and one casualty of this. Most Congress people, if they're spending over half their time fundraising, can't possibly understand all of the really important issues that affect us as American citizens. It's a lost opportunity to build relationships with each other. Half the time spent fundraising means that members of Congress don't get to know each other. They're not friends with each other. They don't have relationships. And don't we see this in our gridlock and animosity? They're telemarketers competing with each other. The effect of money determines how they vote. The third lens, the money lens, the big donor lens, has become the most important lens over the lens of constituents, over the lens of what's good national policy. How will my big donors react to this? When a bill gets passed, when gridlock gets surmounted, it's usually because the big donors are compromising with each other. The public's view of increasing amounts of money has created the most deleterious effect on our nation. People say, why vote? Big money talks. Big money controls everything. Good people have fled at the town square, and corruption has rushed in. Change is not going to come from Congress. The state of Maryland has the power, the right to exercise. The Founding Fathers gave us a gift. Let's use this and put the state of Maryland on record for a convention of the states to overturn Citizens United and guarantee every citizen's right to vote.
Thank you, Ms. Ogden. Next.
Hello, my name is Bob Goulden, also with the Maryland Committee to Amend, and I would like to speak briefly about another aspect of this problem, which is how the extraordinary power of money in the political system systematically skews the outcomes of the political system so that we wind up with some quite bad legislation and public policy. I mean, people naturally tend to focus on the fact that this is, that poor people and working class people get shut out of the process, and that a lot of special benefits, such as tax breaks and subsidies and very favorable regulations, come to the richest elements in American society. And this is true. But I want to point out that it goes even further than that. Because of the influence of moneyed interests in the policymaking process, we wind up with policies that really don't make sense for the society as a whole, including all classes of society. Let me just point out two examples. One, I did some research. The largest donor to the 2014 electoral cycle, the one that we just went through, was the finance, insurance, and real estate sector of the economy. They donated or otherwise inputted $499 million. That was number one among financial sectors. And I would have to ask you, what have we gotten for this extraordinary influence of the financial sector over public policy? Well, during the late 90s and early 2000s, we got the deregulation of finances. And as I'm sure you'll remember, the financial sector went kind of nuts with derivatives and mortgages that were worthless. And basically, the financial sector built a house of cards. And then in 2008, as you remember, it came crumbling down. And then what the financial sector did was go to the U.S. government and say, help us. We're crashing, we're crumbling, and we need your support. And we did a bailout to the tune of $840 billion. And, you know, so on the way up, the financial sector got its way, and on the way down, they got it as well. I see that body language, Mr. Chairman. Okay, the other thing was, I just want to point out that in the kind of health care that we have, health care is a huge industry, and it has also It has also contributed $138 million to the last election cycle. What do we get for that? We get the most expensive health care in the world. Our per capita expenditures on health care are far higher than any other countries. And yet, surprisingly...
Mr. Golden, we've exceeded. We have lots of people behind you, and they deserve time too. So you have to close.
Okay. Thank you very much.
Madam Chair and members of the committee. Oh, is it on? Charlie Cooper, President of Get Money Out. Thank you very much for this opportunity to speak in favor of this important resolution. And thank you so much. Some of the committee members were here last year when you made a favorable report by a bipartisan vote of 9-2. There's a lot in my written testimony, but I really just want to focus on the convention and why the convention is really an opportunity, and why the convention process is an opportunity. First of all, it's clear that that convention calls are separated by topic, and other states are asking for conventions on other topics. We can't stop that. If they get 2/3, there'll be a convention on their topic, but it's very clear that they're not counted together. The Congressional Research Service, the Department of Justice in 1987, and the American Bar Association have all issued reports indicating that a convention can be limited. Furthermore, if we get 34 states to do what we're asking you to do today, right now we're at 4 states, but if we get 34 states, the people in this room, all of us are unpaid volunteers at Get Money Out, will have won over these money interests, and we will keep this convention on this topic because we will have millions of people all over the country. The other thing is we're building relationships with the legislators all over the country. You know, Wolfpack is operating in 40 states, and it's so much more accessible to the citizenry than the Congress is. And this paves the way for the ratification of a good amendment. But one of the things that happened with the Equal Rights Amendment is it started the other way, and then there wasn't enough relationships in the states, and so they couldn't ratify it. These convention calls do not have time limits. They go on. We, in Maryland, issued one in the 1970s. It's still there, and other states are still referring to it. So we could look at that. We could rescind that maybe if we wanted to. But there's just a lot of advantages to this. To us, it seems that 2/3 of both houses of this Congress is a completely impossible way to solve this existential crisis for our representative democracy. And so we ask you to step up and be one of the 34 states. You have 3% of all the power we need to do this. Thank you very much.
Thank you, Mr. Cooper. And finally?
Good afternoon, Mr. Chairman. Good afternoon, Mr. Chairman. My name is Patrick Enright. I'll be quick. I want to take this to a very personal level. I want to speak for those who cannot be here to speak for themselves. I wish to say that, and I submitted written testimony also, I wish to say that all U.S. citizens are degraded, demeaned, and insulted by this despicable Citizens United decision. In particular, our citizen veterans, past, present, and to be, to include those citizen warriors serving in uniform and dying and sacrificing themselves today. I submit to you that these citizens sacrifice themselves to ensure and secure the liberty of this country and their rights as citizens bestowed upon them by their nation. I submit to you that not one corporation froze at Valley Forge, not one corporation shed their blood on the decks of the frigates Bonhomme-Richard and Constitution or on the ramparts at New Orleans. Not one corporation charged the machine guns in Bellawood or inhaled the lethal gas at Chateau Thierry. Not one corporation, I assure you, did not get cut down on the beaches of Normandy or die on the hot sands of Iwo Jima and the crowded beaches of Tarawa. Not one. Well, who did? The employees of the corporations and organizations and companies who left their jobs, their families, their homes, answered the call to defend their nation and secure the rights and liberties for all citizens. Their service is degraded and demeaned by this decision of the Supreme Court. Ask yourselves, did these citizens fight to secure the dark blessing of corporate personhood, or to secure the dark blessing of corporate free speech for corporate coin? I certainly hope not. I don't think so. So we citizens today, through you and your good offices in this committee, have the opportunity to overturn all of this and restore citizen rights. I urge you, no, I beg you, to issue a favorable unanimous vote for a favorable report to send this resolution to the floor of the Maryland Senate, to encourage all your fellow senators to do the same. Send this resolution out the door, down the road, westward to Washington. And also, in addition, please do the same for Senate Bill 340. Thank you.
Thank you. Questions for this panel? Senator Bates.
You mentioned Wolfpack. How is that funded?
Wolfpack receives all of its funding from the members of the audience, as well as a little bit of funding from the Young Turks, which is the largest online news show in the world.
Okay, so, and you file campaign reports or no?
That's correct.
Are you subject to any limitations on your fundraising?
You know, we don't take big donations because I have we don't take, you could look in our records that are posted publicly online, but we don't take big donations.
I didn't see anything, so
yeah.
that's why I was asking.
Yeah, you could find that through the FEC, I think, is where it is. I'd have to talk to the, accountant lawyer people. Okay. But what I do know is that we don't take a lot of big donations from people because we have a theory at Wolfpack that people are always responsive to the source of their power.
I understand. You don't take them from people. Do you take them from any other organizations, any other like nonprofits or anybody like that?
Yeah, the only other organization that we've accepted funds from is the kind of parent company, the Young Turks. Okay. Does that answer your question?
I think so.
Okay.
Further questions for this panel? Seeing none, thank you all. Let me just have a final. So David Ladden, Alan Hyman are not here. Henry Bogdan I didn't see. Eldridge James is not here. So Michael Lohr or Cynthia and William Peel, come to the table. You are the last witnesses.
Mr. Chair, is it okay if I stay if there's any questions?
No, I think that panel was covered. Thank you, though.
So my name is Michael Laurie. I'm wearing my citizen hat today. Most important hat I think that I have. Not a father. That may surpass this role, but to be very brief, I think this is a Me Too testimony. I did want to add, though, that I do think this is a nonpartisan issue. I think part of the problem here is that at the Congress level, they're spending so much time raising money because these ads are negative ads, and they're trying to immunize themselves from these potential negative ads. And beyond that, they could potentially solicit donations from the lobbyists more often than they otherwise would. So they're actually, in some ways, extorting money from the businesses. That's the other end of this, is they're so afraid that these negative ads might be forthcoming that they're going to spend a lot of their time trying to immunize themselves from that potential. And this is just another effort led by citizens and elected officials to overturn bad decisions by unelected courts. And I'll leave it at that.
Thank you, Mr. Lohr. Welcome to the committee.
Thank you.
Mr. Peel, in whatever order.
Hi, I'm Cindy Pyle.
I
came here
apologize
today.
for butchering the name.
That's okay. To give another example of the need for this legislation, I live in Calvert County, Maryland, where every single day we see the evidence of the need for this legislation because of the permitting process that corporate money has funded with the Dominion Corporation construction of the $3.8 billion gas refinery and export terminal. And this has been done in a densely populated community rather than in a remote area. And this is an example of what happens when corporate wealth is accepted and recognized to make policy decisions even on boards that grant permits, while citizens' verbal and written commentary and continual appeals have been completely ignored. Our representatives at the local and at the state and at the federal level have made decisions influenced by these corporate contributions rather than making decisions to safeguard the people. We are now having people who are involved in lots of demonstrations and other activities because they have given up almost on the point of trying to go through the channels necessary to have their voices heard. So I am asking you to please pass this legislation and let the people's voices be heard instead of the money. Thank you.
Thank you, Ms. Pyle. Sir.
Thank you for allowing me to testify today. Again, Cindy and I live in Calvert County. We have witnessed this now for over a year. I'm astonished at what has happened. The Board of County Commissioners signed a non-disclosure agreement with the company. Citizens were not told what was coming down the road here. It is getting so desperate now that 30-plus people have been arrested. Good, honest, abiding, tax-paying, law-abiding citizens are going through what no citizen should have to, throw themselves in front of the bus, literally to stop this from happening. This is totally wrong, that people should have to go to this extreme to be arrested, taken to court. They're being sentences. Some fines are upwards of $500, 3 years probation. This is wrong, that Maryland citizens, again, should be put through this. Again, they didn't have a chance up front to say what was going to come. They're going to have 410,000 gallons of propane sitting next to 14.6 billion cubic feet of LNG gas. They're going to emit over 20 tons of toxic and hazardous carcinogenic chemicals into the air every year. The Maryland Department of Natural Resources knows about this. The PPRP report is full of all kinds of information on this, and yet it keeps going forward. I please beg you to pass this resolution. Thank you.
Thank you. Any questions for this final panel? Seeing none, thank you all for your patience. That concludes the hearing on Senate Joint Resolution 2. And Madam Chairman?
Moving on. We're going to now do Senate Bill 536, Certified Public Accountant Definitions, a Test and Practice Certified Public Accountancy. And Mr. Tom Hood, Nick Manis, if you would come forward. Let me just briefly say, because see, I'm straight into the point. It doesn't take me long to do what I need to do. What this bill does, it redefines the definition of a test and practice of certified public accountancy in conducting audits or review with the statements and standards of the American Institute of Certified Public Accountancy. Ta-da, I'm done. And Senator Bates, you know exactly what I'm talking about.
Thank you, Madam Chairman, members of the committee. Nick Manis here representing the Maryland Association of Certified Public Accountants. First, we'd like to say thank you to Madam Chairman for introducing the bill. The bill has some drafting amendments that we are supportive of, and as the chairwoman said, it conforms Maryland to the Uniform Accountancy Act, and with that, I'll let Tom Hood from the Maryland Association of Certified Public Accountants also give some testimony.
Thank you, Nick. Madam Chair, thank you, and members of the committee. My name is Tom Hood. I'm the Executive Director of the Maryland Association of Certified Public Accountants. We represent 9,000 CPAs in the state of Maryland. This bill is what I call minor technical correction to bring our law in sync with professional standards. So it's just a minor piece. Madam Chair, we really appreciate you introducing this piece of legislation. The State Board of Accountancy has worked with us on it, and there is no opposition. So we hope that you will give it a favorable report, and we appreciate that.
Question?
Favorable with amendments. Thank you, Senator.
All right. Questions? Senator Bates, you have any questions? All right. Thank you. That concludes the hearing. Okay. Well, let's do Senate Bill 203 very quickly. And this bill is business occupations, professions, real estate salespersons and brokers, formation of business entities, and payment of commissions. And I think what we did with this bill, let's get Mark Fenroth and Michael Vorget. Okay, Mark, you want to do it or you want me to do it? You can start.
As you prefer, Madam Chairman. Thank you. Thank you for your friendship and your sponsorship of this bill. I'm Mark Feinroth on behalf of the Maryland Association of Realtors. Our 22,000 members ask for a favorable report on this legislation. And what this does is add two types of entities that we can organize real estate agents as under teams and groups. It will allow them to be formed as corporations and partnerships. Unfortunately, the original law didn't include those options, and with the advent and proliferation of teams and groups in the practice of real estate brokerage, that's become an increasingly important kind of function for them to be able to do. And under the current act, the broker cannot pay them their commissions if they're formed as corporations or partnerships. Only as LLCs and individuals can they receive their commissions from the broker. So this will allow them, with the broker's consent, to organize themselves as corporations and partnerships.
Questions, committee? So we just adding another layer in terms of giving them the flexibility to actually pay that individual?
They're giving two more options.
Right.
Two more options in the way they organize themselves.
Okay. All right, I don't see any questions. Do you have a question? All right, that concludes the hearing.
Thank you very much.
Senator Bates, let's we were waiting for Senator Glassmeyer, but she's not here, so we're going to do your bill.
Senator Pinsky has a real quick one, too.
Senator Pinsky?
He has a real short one.
All right. Senator Bates. This looks like my bill. Senator Bates, Senate Bill 324, Minority Business Enterprise Participation, Liquidated Damage, Architectural and Engineering Services. Can't even
what
talk.
she said. Thank you, Madam Chair,
right.
members of the committee. This is a bill that I don't know all the details of it, but I know it's designed to reduce the impediment in some ways of minority businesses. It is to exempt small specialized minority businesses from the liquidated damages provisions that tend to favor larger corporations rather than smaller businesses. And I'm going to let others who know more details please give the details to the bill, but we would request a favorable.
Thank you very much, Senator Bates and Madam Chairman, members of the committee. I'm Chris Costello. I represent the American Council of Engineering Companies here in Maryland, and I know they've been before the committee before, but for those who have not been on the committee, it's 90 multi-sized consulting engineering firms that are located throughout the state serving public as well as private sector needs. 30%, and actually it's more than that, of our members are certified minority or women-owned firms and small businesses. And 6,000 employees and are responsible for the design of most of the area's infrastructure, environmental, and building construction. They focus on the business aspects of consulting, engineering, and surveying professionals. It's one of 51 member organizations around the country. This issue has been coming to a head for some time. Several years ago, a bill was passed requiring that all state contracts that include goals for minority participation should include a requirement or an application of liquidated damages, that which had been in the law for some time, but had not been specifically required to be listed into contracts. And while certainly the engineering firms have the best record, I think, of any industry in meeting this requirement in terms of total participation, a lot of the contracts and the way contracts are done with the state are different for those entities that are subject to what's called qualifications-based selection. And I have two engineers here who will explain it, but while you can certainly understand liquidated damages is a real incentive to comply with minority contracting, what this is doing is actually having an adverse, unintended consequence, and it's actually not doing what you want it to do. It's having the exact opposite effect in some instances. And we have some examples that we can speak to here with, I have Sean McCone at the very end here. He is the Vice President with JMT Engineering and deals with these contracts. and we have Laura Soprano, who is with a minority firm and can speak to the impact that this has. The Assistant Secretary for the Governor's Office of Minority Affairs is here. Last year, we had this bill in the House, and we were asked to sit down with GOMA, which we did over the summer. And we tried very much to try and find a solution to it. I believe that GOMA is doing exactly what you want them to do and what they are required to do. What they probably cannot do is something that is not required or approved under law. And if we're going to find a way around some of these problems where some minority firms are being left off of teams in favor of more diverse and less specialized firms, we're going to have to do something that's going to require a change in the law, we believe. And that's what we're doing here, what we're attempting to do.
Chris?
Yes, ma'am.
I think we got it. You
Okay.
want your...
Sean McCone.
Oh, hello, my name is Laura Soprano. I represent RJM Engineering. We are a minority-owned small civil engineering firm in Ellicott City, Maryland. We've been in business around 20 years, for about 20 years. We want to thank you for the opportunity to speak to you today about the negative impact the liquidated damage clause or provision has on MBE firms in the AE community. Although AE firms are represented here today, but the principle we're discussing today is applicable to all professional services. We understand this provision has helped many MBEs in many industries. For example, the construction industries, where the services are procured through a very specific scope and fee. However, AE services are procured differently. Most services are procured through a qualification-based selection process. Through this process, a typical contract will have a general description of services to be provided with no specific scope, and there's an upset limit compensation fee for the term of the contract. So as a MBE firm on the winning contract, we understand, being on a winning team doesn't mean you will get work, because the client, ultimately decide, if any work is going to give out, how much work and what type of work. So to penalize the prime consultant for the decision, the client makes, makes no sense. So, at the end, this provision is fixing a problem that does not even exist in the AE community among the MBEs. We understand if the client does not give out assignments that we have expertise for, we're not, expecting any work out of the contract. And also the MBE compliance in Maryland in the AE industry has been excellent. We are responsible for submitting MBE reports on a monthly basis to all clients to confirm we have received payments. These statistics, there are statistics to verify this track record. But the bigger problem is this provision actually will cause damages that you probably can't even quantify. Like Chris said, to prevent, from being penalized for any damages, the prime firms will most likely use MBE firms with larger firms with multidisciplined capabilities. Smaller specialty firms will most likely get less or no work. If you don't have any work, you'll go out of business. Secondly, the assignments that's going to be given out to MBE firms will be assignments that's easily budgeted and easy to manage, such as staffing needs, services. Meaningful design contracts will not assignments probably will not be signed to smaller firms. With that being said, I don't believe this was, the legislation intended for. So it's time to change. Thank you.
Thank you, Madam Chair, members of the committee. You have our written testimony. I'll keep my remarks brief, but I do want to hit a couple points. My name is Sean McCona with Johnson, Murmuray & Thompson. We employ 1,100 folks, 450 in Maryland. We're a larger AE firm. I am also a director of ACEC. I was down here when we supported your bill, Madam Chair, 2 years ago, Senate Bill 188. Unfortunately, we submitted it before the liquidated damages provision came in towards the end. It was added at the end. And I just want to point out a couple of things. Our industry is very different than the contractors. Obviously, this bill is aimed specifically at that. It affects the procurement because we go through a different procurement process. Liquidated damages, they're a good tool in the toolbox. They're a small rock hammer when it comes to architects and engineers. We get selected by qualification based. If we don't meet our goals, we don't get another contract. This seems to create a lot more problems than it actually presents in our industry. It also.
Excuse me 1 second. Sharon Klassmeyer, you're going to be next. This is the last. Okay. All right. I just didn't want you to go far. All right. All right.
So it
I'm
is having
sorry.
some.
You can continue.
That's okay. I'll be brief. It does have some unintended consequences. I mean, the way it's been implemented, the regulations have been a little ambiguous. We did submit some information to go along with it of some of the ways that they are implementing it. Mm-hmm. If I could point out your attention, one of the University of Maryland Baltimore procurements, their liquidated damages is written as this: the failure to meet the contractor's total MBE participation goal and sub-goal commitments. The actual damage that we have to pay is the difference between the dollar amount that we committed to and the actual one we achieved. So it's ambiguous, and you'll hear testimony, I think, later from GOMA saying that's not the way they're implementing it, but that's the way they are. It's not clear, and every year we're going to have to go back and renegotiate. The only solution we see is to legislate this. The other unintended consequence that she said, yes, we're selecting MBEs that are going to be big. We're engineers. We're risk adverse. We're going to pick people that we know we can meet this. We don't even want to take it to the point where we have to go back and forth with GOMA whether we're meeting it or not. You see some of the other ones in there about our liquidated damages. If the failure of the subcontractor, our minority subcontractor, submit their report, we got to pay $30.59 per day. We're going to pass that down to the MBEs. And we might even pass it down with a markup or something along those lines. Same thing if we don't include this, or we don't include that, or we don't meet the goal because of them, we might pass those damages down along to them too. And we don't want to do that, especially in an industry where we're partnering with the state. The engineers come in and we're working with the state to develop solutions on areas they don't even have scopes with. I personally feel liquidated damages is not the tool you need to use in a professional services industry when you really want that fiduciary relationship. You're not going to have a doctor, a doctor's not going to sign a contract if you say, hey, if you don't finish that operation in 2 hours, you got to pay me $1,000. Those good doctors will walk away, and you might get the doctors that take on that extra risk. So, I appeal for a favorable report on this bill. I think, the perception that you might not be helping small businesses by passing that is not true. This definitely will help small MBE businesses, and I doubt you'll find any small architectural engineering firms in opposition to this. So, appeal for a favorable report, please.
Senator Wah.
Thank you, Madam Chair. I have to say I have a lot of experience with contracting, and I have bought and sold everything from secretarial services to spacecraft and spy planes, firm fixed, cost plus, time and materials, you name it. I've done a lot of contracting. I feel like a dog watching TV. I do not understand what we are talking about here with liquidated damages. So just please, very simply, what is this provision?
Go ahead. You want to explain?
Yeah, I'll go ahead and answer this. So contracting units by the Senate Bill 188, which is now law, require all the procurement officers to include liquidated damages. And those are agreed upon damages in advance of real damages in a contract because you can't quantify certain things. So the state is damaged if we don't submit our MBE reports. They have to have someone go chase them down, and it takes so much time. So therefore, they should calculate it takes $30.59 of someone's time for the state to go chase down why we have not submitted our reports. And I'm sure the Assistant Secretary could probably answer this better than me. But normally, you see a quantifiable and calculated what a liquidated damage is. ahead of time. So in some of the other ones in CD, those are kind of somewhat unquantifiable, and who actually is getting damaged and who's receiving those damages is a different mean. I'm not sure if I explained that as well. I could try another example for you if you'd like.
Well, one thing that might help you is in the primary problem here is that the liquidated damages was requirement. There was a requirement that every contract subject to minority goals must include a statement and requirement the liquidated damages will be applied if you fail to meet your minority goals, that is for including minority firms. What happens, though, is that sometimes you have a goal or you agree to a goal, but you don't know that you're going to actually get the work from the state to provide that minority firm. And so you're not at fault for the failure to meet that goal. The state really knows that. And yet you are subject to these fines, which could essentially make the whole project unprofitable. Now,
but there's the threat of the fines. I should say the threat of the fines.
Well, yeah. What will most likely happen is that the contracting agency will say, well, literally speaking, we're told if you don't meet this goal, we have to assign liquidated damages. When in eventuality, this will go through a long and convoluted process, an expensive, time-consuming process, at the end of which GOMA will probably, and I think almost in every instance, say, well, that's not your fault. We can't agree to have liquidated damages there. Well, the threat of that is enough for these firms to say, we're going to have to go, through all kinds of contortions to make sure that we can always meet this goal, no matter what. And so when they do that, they end up, one of the things they do is they just carve out the small specialized firms, which is exactly the opposite of the intent of minority contracting, is to get these startup companies, generally specialized, get them into the market, help them grow, and no organization has done a better job at nurturing these small firms than the engineering community. But now, when we're doing the state contract, it's actually working against us.
Senator Weil, you understand what he's saying?
I think I'm getting it. Yeah. I think I'm getting it.
Okay.
All right. Thank you.
Right.
Thank you.
Sure, yeah.
Appreciate the question.
I think I've almost got it too. I'm exactly the same place Senator Wall was. I heard you say a lot, but I didn't hear what you said.
I'm sorry.
You're simply saying that if you have to pay liquidated damages, you might have to stop using small firms, minority firms?
Yes, that is one way to avoid even the threat of liquidated damages for not meeting a goal. So if you have a diversified firm, minority firm, and say they can do civil engineering, mechanical engineering, geotechnical surveying, that sort of thing. So you don't get the geotechnical, if that is such a thing.
You don't have to go through examples. I'm just trying to find out.
But
exactly
you'll use
what
that
you're
firm.
saying.
You'll use that firm so you can make sure that you're going to be able to meet the goal. But what happens is that the small. Yeah. Go ahead. Well, maybe I'm wrong.
I think he got your point.
Oh, okay.
I think I've got it now.
Okay. Did you finish?
I did. I'm just here to clarify questions.
Okay. Is there any further questions, committee? Okay. Is Carmina Perez Fowler here? All right.
Thank you.
Thank you.
Thank you very much. Appreciate it.
All right, Ms. Fowler.
Yes, my name is Carmina Perez Fowler, and I am the Assistant Secretary for the Governor's Office of Minority Affairs. We submitted written testimony also regarding concerns about this bill. Generally, just again, this bill, the statute was enacted in 2012 as a way of ensuring and being compliant. Basically, there was a little contracting officer agency could do if the contractor failed to meet the MB requirements. One aspect, so in 2012 the law was passed, 2013 the regulations were passed, and we developed some guidance as to how to assess liquidated damages. And the statute says liquidated damages are assessed only if a contractor fails to meet the goal in good faith. And I think what all the testimony you heard, everything that they said will not be assessed liquidated damages, because if the state gives you a task order, you cannot use the MBE for reasons outside your control. If the state changes, if they don't, again, it's not meeting the numerical goal, it's not meeting your commitment, it's meeting whether you try in good faith efforts to meet the goal. So every circumstances that the panel before me described will not be a situation where liquidated damages will be assessed. Their arguments, and based on my conversation with them, is that the threat of liquidated damages is therefore enough for them not to put the small A&E firms on their MB participation schedule. It's just a threat because, to our knowledge, liquidated damages has never been assessed against an A&E firm ever. We have not received any complaints from anybody, including the A&E community, as to a specific project where a procurement officer said, I'm going to be assessing liquidated damages against your firm. We don't have absolutely no evidence whatsoever this is a problem. Their whole argument is that because of this threat, they're going to change their business practices and they're only going to hire bigger A&E firms in case there was a misapplication of the statute. I don't think it's sufficient to accept them completely from their requirement. Again, we have told them that we work with them. One issue that we said, we actually issued some guidelines about how to assess liquidated damages, and it's a very lengthy process in terms of, and there's all kinds of review by the council, procurement officer, MB liaison. Then there's a notice to the contractor. There's an opportunity for the contractor to say, no, I did act in good faith, present evidence to the agency, and then you get assessed liquidated damages after a review of that evidence. So I'll be happy to share those guidelines with you. Again, it's not, this statute was not meant to assess liquidated damages if a firm acted in good faith. And all these examples, again, that you heard are examples of the firm did act in good faith, therefore no liquidated damages will be assessed.
Senator Bates.
The process, you said no liquidated damages have been assessed. I think the concern that I heard, and this is part of the reason for the bill, I believe, is that there's a process they have to go through to prove that they would not have to pay liquidated or be charged for this, right? I mean, you have to go through to prove that you've done everything.
No, actually, there's an investigation before you even think about assessing a contract or liquidated damages. There's a whole compliance procedures to that the compliance MB liaison officer will have to check why they're not meeting the goal, what task orders were issued. Okay. So it's not like the minute they don't meet the numerical goal, there's liquidated damages.
No. I understand that part. I think some of the concern is that additional process that they need to go through to prove that they were not at fault, that then takes time, it takes effort. Is that what I was hearing?
Yes, I mean, the engineering firms will always comply. They will always meet every goal, but it's the way they are forced to achieve that goal that's having an adverse effect.
You can't, the committee can't hear you if you talk from the audience. You have to be at the mic, Mr.
That's
Costello.
correct. I mean, the reason that you're not going to see any liquidated damages actually applied is because the engineering firms are going to use other methods, that is, to make sure that they meet every goal. So there will always be minority compliance. But it's a question of, well, that's not the minority compliance we were hoping to see. We were hoping to see these small minority firms. And the reason that this whole thing is come about is because it has nothing to do, no criticism towards GOMA. It is, there is already a process in place under Section 13 which deals with this type of contract that ensures that they're going to meet all these goals, and now you have liquidated damages on top of that, which actually are pushing this out of shape. So what we're hoping is that we'll have confidence in the procurement law that has really proved very effective up until now in achieving all these goals. They've always met their goals. I don't think there's ever been an instance where they didn't. So now they're meeting their goals again, so there's not going to be liquidated damages, but you're seeing things pushed out of shape, and you don't want that.
Good.
Thank you.
You done? Let me just say this. I understand what you're saying, and obviously there seems to be a problem as it relates to liquidated damages. But just based on what the governor's office of, what Gomer said, and then there's another bill, hopefully with the compromise that we will study it and come up with a solution. And then I see the bill that says prohibition on liquidated damages, so I was a little taken back. So I don't think that, and this bill has opposition to it. But I thought we were going to work our way through this and come up with an agreement in terms of the utilization of the smaller minority businesses so we could take that liquidated damages portion away, not a strict prohibition, because I don't think we're going to get there with that.
Yeah, and a letter of concern, we also support your efforts for the task force.
Thank you. It's not a problem. Any further questions? All right, thank you. Senator Case Meyer. 3:30, Class Meyer. Look, Case Meyer. I've had so many bills today. Come on, Senator Class Meyer. You have Senate Bill 330, County Code of Public Local Laws, 2015 edition, legalization.
Yes.
I know.
Good afternoon, good evening. And Madam Chairman, I just would like to thank you very much because our committee room was toasty this afternoon. So thank you.
After y'all froze me out yesterday.
Yes. I actually had to take my jacket off for a while. Senate Bill 330, Baltimore County Code of Public Local Laws, 2015 edition, legalization. Senate Bill 330 is a local Baltimore bill, Baltimore County bill that has been passed by the Baltimore County Senate delegation. This bill legalizes a 2015 edition of the Baltimore County Code of Public Local Laws and any supplement to it that contains laws enacted by the General Assembly. Joining me in support of Senate Bill 330 is Sam Moxley, Assistant County Attorney, who is speaking on behalf of the Baltimore County Administration. I thank the committee for their consideration of Senate Bill 330, and I ask for a favorable committee report. And I believe this is very similar to some of the code revisions we've done here in Annapolis. So,
Okay. Is Ethan Hunt here?
Ethan had to go to school.
So Sam is
Yes,
taking
ma'am.
his place. All right.
If that's fine.
Good afternoon, Madam Chair, honorable members of the delegation. Sam Moxley on behalf of Baltimore County Executive Cabinets and the administration. We believe that this bill is a housekeeping bill. Throughout the years, Baltimore County Council passes laws, as does the legislature. We make them part of our code, and this will legalize the new code that will be out. We ask for favorable.
Questions, committee?
Thank you.
All right. Thank you.
Thank
There's
you.
no opposition to your bill. Senator Penske, Senate Bill 610, Real Estate Brokers and Salesmen, Continuing Education Requirements. You better not let Senator Dallas see this.
I'm sorry, who?
Don't start.
Madam Chairwoman, you have a great memory. This is a small cleanup bill. I got a chuckle on that one.
It's a joke because for the committee members who did not know Senator Della when he was here, he had a real issue with continuing education credits, especially with the realtors.
Absolutely, Madam Chairman. This bill does two things. We'll save the best for last. Apparently, most complaints that come in have to do with agency and broker supervision in terms of licenses and who benefits. And what this does is sets certain courses, instead of having to be taken every 4 years, every 2 years. So the agency course would have to taken every 2 years instead of every 4 years, and the course on broker supervision would have to be taken every 2 years instead of 4 for brokers, branch office managers, and team leaders. The last part of the bill, out of the 39,000 brokers or agents who have to take continuing education, a number of years ago, an exclusion was included that said if you had a master's degree or a law degree, you didn't have to, or take the expanded number of continuing education. This bill would remove that exemption, so all people would be up to date on changes to real estate law.
Questions, committee? All right.
Mark Feinroth on behalf of the
Hit the button.
Mark Feinroth on behalf of the Maryland Association of Realtors. Senator Pinsky very graciously sponsored this legislation for us. We thank him for it. And as he correctly said, 15 hours of continuing education will now be required for all licensees. A real estate license is for 2 years. And as he said, broker supervision for those who are required to take broker supervision will now have to be taken every 2 years instead of every other licensing cycle. And agency, which is the prime area for real estate complaints, will have to be taken every 2 years by every licensee. And that's the whole point of the bill. It's driven by consumer complaints, and we're trying to make sure that our members, who are about 2/3 of all licensees, do a better job taking care of their consumers and their clients, and that we drive down the number of complaints that the Real Estate Commission has to take care of.
And what was the most frequent complaint?
Well, agency and broker supervision are implicated in a very large number of the complaints, and I think the more serious complaints are dishonesty complaints, not negligence complaints. So people stealing money and making off with escrow accounts and things like that, that's not something that I think continuing education is going to be able to solve. That's the more common complaint that is the most serious. But after that from the people that are negligent and misinformed that CE can handle, it's agency and broker supervision.
Okay, thank you. All right, that concludes the hearing on Senate Bill 610.
Thank you.
Okay, that concludes all our hearings for the day.
Want to do voting?
Don't move, don't move. We'll vote a few. Here, you
Probably
take
put
this.
this right on here.
Okay, we want to do this while it's fresh in your mind. Okay, we had Senate Bill 215, remember the act?
Sir?
No. You remember the Astle bill, they said less than 200 feet, less than 12 feet draft? Senator Astle's bill allowing the ships to come in that did not have a bay pilot. We want to vote that if there was no opposition to the bill. No, this is the recreational, he's messing with us. This is the recreational vessels, okay? Sure, sure. Turned on. Oh, we'll do a lot of site visits, you can believe that.
On 200-foot yachts, though, Madam Chair.
On the boats.
On the boats.
Yes, and we've even been on the huge cargo ships.
Sweet.
We had to, on one of them, we had to actually climb up the ropes to get there.
Wow.
Yeah, we did the ropes to get
right.
there. So, no, we do a lot of visits to the
All
port.
right. Awesome.
And a lot of ships, boats. Very interesting. Motion on the bill, or is there any questions about the bill? It's Senate Bill 215. Okay. Motion is for a favorable committee report. Is there a second? Senator Salling, a question? If not, all in favor of the favorable committee report, aye. Anybody opposed to the favorable committee report? Oh. Yeah, Classmeyer was easy. There was not, that was,
She was 610.
yeah, 610, there was no opposition to her bill.
No, she's not 610.
No.
She's not?
No, that was
Oh, I'm
Senator
sorry.
Penske
I
with
apologize.
610.
330, the bill we just heard?
Yeah. No, Penske was 610.
I apologize. I was
Okay.
back with the
All right.
guest.
Well, we can actually do 6:10 while we're looking for 3:30. Does anybody have a problem with the continuing education credits of Senator Pinsky's bill? Okay. Oh, the real estate person moves favorable. Okay, it's been moved and properly second to send Senate Bill 610, which is the continuing education requirements. All in favor? Anybody opposed? Okay. Okay, hold up. No, they're today's bills, Senator. We're voting today's bills now, darling. They're not on any list, and that's how we're going to vote from now on. You may or may not get a list. The easy bills, we're trying to send them to the floor, because I'm telling you, after crossover, we go to the floor like this, and when we go to the floor like this, and we even try to put a lot of the bills on consent, but they pull them off, so your bills fail. So we vote them this way, or we already know your bill's not going to make it to crossover. They'll fail, because they're going to hold them. All right, I just saw another easy bill. Which one was it? Oh, the certified public accountants. They redefined a test and the practice of, certified public accountancy. But it's one amendment to the bill. Sir, you want to tell us what the amendment is?
Yeah, the amendment, for that, I think clarifying it restored language in the bill that had
536?
536.
We already
Sorry, Linda.
voted that one. 330.
The amendment should be in your file, and I also provided you with a reprint. So if you just look on page 2 of the reprint, apparently the way the bill was drafted, it removed the ability to conduct the examination, which was the whole point of the bill. It also took out the language about the compilation of the financial statements, which they still need. It's being taken out of the definition because it's already part of the statements on standards for attestation engagements, so this follows.